After its beaches, the second most popular thing about Goa is probably its uniform civil code. But it's not as uniform as it's made out to be. Consider this for example. If you're a Hindu man from Goa, you can actually marry a second time, that is, marry twice, if your first wife does not give you a son by the time she's 30. This, of course, won't be allowed. It won't stand anywhere else in the country. So the civil code in Goa, like I said, isn't as uniform or just as it is made out to be. And that's what I'll be telling you about in this episode of KYC or Know Your Constitution. Now, let's begin with the basics. What does a UCC mean and what does the Constitution say on it? The Constitution basically mentions the Uniform Civil Code in Article 44. It says, and I quote, that the state shall endeavour to secure for the citizens a uniform civil code throughout the territory of India. But there's a small catch. Article 44 is a part of the directive principles of state policy. The point here is that while the government is duty bound to apply these directive principles while it makes laws, you can't approach the court to enforce directive principles. So in contrast, if the UCC was under the fundamental rights section, anybody could have approached the court asking for its enforcement. But since it's a part of the directive principles of state policy instead, this cannot be done. And the parliament hasn't so far brought in a law on UCC so far as well. And okay, what does having a UCC do? So basically, while criminal laws in India are uniform and applicable equally to everybody, no matter what their religious beliefs are, civil laws like those on marriage, adoption, divorce, and succession depend on the religion of the parties. So Hindu personal law is largely codified in 4 acts. You can see them on your screen right now. A large part of the Muslim personal law is still uncodified, but certain aspects are covered by laws such as Muslim Personal Law Shariat Application Act 1937 and the Dissolution of Muslim Marriage Act. We also have the Indian Christian Marriages Act and the Indian Divorce Act for Christians and the Parsi Marriage Act and Divorce Act for Zoroastrians. There are more national laws too which disregard religion altogether. For example, we know about the Special Marriage Act under which interreligious marriages can take place. Now, whenever we talk about the UCC, of course, Goa comes up as an example to follow. Even several judgments have hailed Goa for its UCC and have spoken about it. To let you know, Goa currently has the Portuguese Civil Code 1867, which was given by the Portuguese to Goa. So basically, the Hindu Marriage Act, Hindu Succession Act, or say the Indian Succession Act, Shariat Application Act, or the Dissolution of the Muslim Marriage Act, none of these laws apply in Goa. It has its own code. But like I mentioned, the Common Civil Code isn't as uniform as it seems. For example, though polygamy is not allowed for registered Muslim marriages in Goa, bigamy is allowed for Hindu men under certain circumstances under another law in Goa. It's actually called the Codes of Usages and Customs of Gentile Hindus of Goa. So the law refers to them as Gentile Hindu men. And under what conditions? The law says that bigamy would be allowed if the wife fails to deliver a child by the age of 25 or if she fails to deliver a male child by the time she's 30. So bigamy in India is of course prohibited under section 494 of the Indian Penal Code. In fact, it can be punished with a 7 years jail term and fine, but this law in Goa allows it. We also have Article 1057 of the Goa's Code, which provides for the registration of marriages, but the system again is different for Catholic and non-Catholic marriages. First of all, couples need to inform the civil registration authorities that they want to get married for Catholic and non-Catholic couples, and then after 2 weeks, they can sign a marriage deed. For this, second signature or confirmation, for Catholics, it can be signed before the church, and for non-Catholics, it needs to be done with the civil registrar. So they have different procedures. Also, those marriages which have been solemnized in the church, they have the option of being annulled in the church for specific reasons such as non-consummation of marriage. And once a marriage is annulled by the tribunal of the church, the annulment is then confirmed by the High Court, which is usually a mechanical procedure. But non-consummation is not a ground of annulment or divorce for non-Christians. For them, Article 1089 says that such a power to annul marriage can only be exercised by civil code. So there's again a difference there. There are other discriminatory provisions too. For example, The law permits only males to be adopted by Gentile Hindus in the absence of legitimate male children, and a challenge to it is now pending in the High Court of Bombay at Goa. Another such provision says management and administration of the properties of the couple and even exclusive properties of the wife belong only to the husband. And while the law permits the husband to get a divorce if adultery is committed by the wife can get a separation only if the husbands commit adultery with public scandal, or if he keeps a mistress in the conjugal home, or if he completely abandons her. So, like I said, while we might hail the Civil Code of Goa as an example, an independent study on what provisions need to stay, which need to go, and whether a civil code is even needed needs to be considered first. That's all I have for you for now. This is Apoorva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram, and Facebook.